Good morning, you're trailing Hill. Let's see, what is it?
It's a motion for continuance. Filed by Mr. Matuska, Your Honor.
You just paid the bond before.
Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? I don't see the motion.
This hearing starts in a tense and unusual place. Before the facts of the case are even discussed, the court is already dealing with communication breakdowns, missed meetings, refusal to cooperate with counsel, and concerns raised by the jail itself. When a defendant refuses to meet with their own attorney, it raises red flags. Not just about preparation for trial, but about whether the defendant fully understands the seriousness of the situation they're in. That's why the court doesn't hesitate to pause everything and order an evaluation. This isn't punishment, it's protection of due process. The court wants to be certain that the defendant is competent, informed, and able to meaningfully participate in their own defense before moving forward.
What I'm looking for. It may be one of the...
Which cases that order?
All four. I just got a script error. Do I hit yes or no?
Yes, it's fine.
Sorry, now my computer's acting up.
Did you try it? John, did you try it?
Huh? I haven't seen it yet. It's not even showing up, but now I've gotten to where I can't X out of anything, so. All right, so Mr. Hill's cases are set for trial to begin with jury selection next week. And Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all of the written reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me, to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based
Don't talk, I'm going to talk to you in a minute.
I'm just saying.
Don't talk over people.
I'm not talking over him, let him know.
You're talking over me right now, and you're talking over him.
I own him.
Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons
I haven't been out to the cell in over
that the court may be
5
aware of.
weeks.
But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing to do that.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay? So it's...
I paid for Burbank, I don't even know who this is.
So you, Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your
You
lawyer.
can put up his file
I represent,
on TV.
I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is 'cause
listen.
I've been to court 14 times and I'm looking to go because I have no evidence on me.
Listen,
during this whole entire thing.
you and me both are ready for
Y'all
you to
invaded
go.
y'all invaded
Both
my
of us
identity.
are ready. Go back with the bailiff.
Y'all invaded my
Listen, if they come out to visit
All my
with you, you need to visit with them. Go back with the bailiff.
Hey, watch where you hold me, sir. Don't touch me like that, man. You ain't gotta touch me. I know how to walk, sir. All right, you just don't get it at all.
Your Honor, after the evaluation, if there's maybe another way that we could order some kind of sitting where I can at least give him the opportunity to see him.
Yeah, I can, what we can do after that's done and we get it, if we need to, we can have him, I'll contact the jail and see if we can either have him brought here with guards or you somewhere at the jail where I'll order that they force him to go. Okay?
He has a $55,000, 10% bond, a GPS tether. Sir, these are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address and phone number. You're to have no contact with Alyssa Fulmer. You can't have contact directly with her or indirectly. You can't have third parties contact her. The only one who can contact her on your behalf, potentially, is your attorney. You can't call her, write her, email her, talk about her on social media, contact her through any applications on your phone, through jail calls, through apps that you may have available at the Wayne County Jail. You can have no contact with her whatsoever. Do you understand me?
Yes, Your Honor.
If you see her at a party or, I don't know, the grocery store, you're to turn around and leave immediately. You're to have absolutely no contact whatsoever. If I find out you've been contacting her from the Wayne County Jail, and it will come out eventually, and I find out that you've been calling her through your line or someone else's account, I will suspend all of your privileges at the Wayne County Jail. You will not have access to iPads. You will not have the ability to make phone calls. Do you understand me?
Yes, Your Honor.
You cannot return to the address of 22219 Champaign for any reason. You cannot possess or have access to firearms or other dangerous weapons. You cannot consume alcohol or illegal drugs. You may be subject to testing on demand. And again, you'll have a GPS tether.
This is where the judge draws an unmistakable line. The bond conditions are not suggestions. They are strict, enforceable rules designed to prevent further escalation. The court is crystal clear. No contact means no contact. Not directly, not indirectly, not through friends, family, social media, jail calls, or third-party apps. Even an accidental encounter requires the defendant to immediately leave. What stands out here is the judge's warning about consequences. Violating these conditions doesn't just risk bond revocation, it risks complete loss of privileges while incarcerated. This is the court saying, we are watching, and compliance matters. Bond exists to balance public safety with a defendant's rights. But that balance disappears the moment boundaries are ignored.
You cannot go to where Miss Fulmer lives, works, goes to school, nothing. If you know she's going to be there, you better not be. And we'll see you on December 8th for your probable cause conference and December 15th for your exam.
May I say one thing, Your Honor?
I wouldn't. You have a right to remain silent. Anything you say to me in a recorded proceeding could potentially be used against you by the prosecutor. It's something you should talk to the attorney about.
I understand, Your Honor. And it may be a far shot. I just wanted to consult you about my bond. I wanted to give you.
No, I'm not interested, Mr. Fanto.
Your Honor, number one, he needs, if he posts bond, he'll need to provide the court with an address, which is a little bit problematic with the GPS tether right at the moment. Number two, he would request an officer assistance.
All right, you have you're allowed a one-time visit to obtain your personal belongings accompanied by a police officer. And you must provide a new address to the court within 28 or 24 hours of release. So if you have a place that you're going to stay and you're released, you have to provide that address to the court ASAP. So we know where to send your notices.
Yes, Your Honor.
And we have a DSU report.
I'm sorry, I didn't hear that.
Your attorney requested a DSU report.
The court ultimately chooses deferred adjudication, but this is far from a free pass. 6 years of supervision, continued GPS monitoring, no weapons, no body armor, mental health evaluations, treatment programs, and strict reporting requirements place the defendant under constant accountability. The judge makes something very clear: frustration, misunderstandings, or dissatisfaction with a business or person never justify intimidation or actions that cause fear. Showing up, armed Even when someone believes they're within their rights, changes how situations are perceived and escalates risk instantly. Deferred adjudication is an opportunity, not leniency. It allows the defendant to avoid a conviction only if they follow every rule without exception. One violation changes everything. If you find real courtroom moments like this important to understand, hit like, share your thoughts below, and subscribe for more courtroom breakdowns that show how quickly everyday decisions can turn into serious legal consequences.
So we can get another opinion as to whether or not my bond is appropriate.
Your Honor, I don't think that you are wrong for what you have said. I'm just trying to think about more than myself here.
Sir, just,
All right, well, right now you should be thinking about yourself.
I am, Your Honor. I definitely am. I just know that.
sir, please, nothing further. Thank you, Judge.
Yeah, talk to your attorney about it, Mr. Pavella. You don't want to talk to me directly like that.
I apologize, Your Honor.
All right.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Judge, we are. There's just one matter I need to speak to.
Yes.
Judge, given after reviewing the facts with the complainants, given the quality of the case, the state and the defense were able to arrive on this as what we felt was an acceptable resolution for all parties. My client has been on bond, on GPS, without incident for almost a year. For a very long time, he was on full house arrest and wasn't able to earn a living. He's just now in a position where he's getting back on his feet. The state has no objection to me addressing the fine. I'm asking the court to consider probating all or part of the fine. And I look forward to my client continuing to perform in supervision the way he has in the last year.
All right. So what were your issues? Why did you do this?
So Judge, if I might speak to that. Obviously we all agree that no threats were made in person.
Mm-hmm.
There were some allegations that threats were made over the phone.
Mm-hmm.
At some point, obviously the state took this very seriously. Initially, we were talking about jail time. At some point, after looking at the case, we agreed that a deferred was more appropriate, one keeping with what happened in this case. My client contends this was a big misunderstanding. His appearance when he showed up the next day caused concern.
What was the misunderstanding?
So I was basically, Your Honor, like what I was in full rest. The company has to post signage, proper signage to.
So Mr. Garza was open carrying. He did not believe that the signage at the store complied with what's required by the law. So he did not believe that he was in violation to open carry at the time. Given his conversations with his dissatisfaction with some issues at the store, product he received,
So
he shows up open carrying. Everything kind of went bad from there.
All right. So according to what I've read in the STIPs, and everybody correct me if there is anything wrong in the STIPs, it says that he's upset over some propane tanks.
There was a dissatisfaction with a product.
And instead of just going there and saying, hey, your policy is gift cards, I'm not getting a new propane or something else, you're not getting the money back, all you have to do is accept that. And then if you want to go sue somebody for not giving you money back, then that's what you do. But you don't call on the phone and then show up with body armor. I mean, that's what it says in the STIP.
And the idea that him showing up in that obviously caused a great deal of concern.
Mm-hmm.
The police were called out. He was arrested without incident. He made bond, and he's been supervised without incident ever since.
Do you have any children?
No, Your Honor.
All right, probation, this is what the court is going to do. It's $1,000 fine. It'd be probated, 6 years deferred adjudication, continued GPS partial for employment only, no employment as a home health care provider or with minors, no possession of body armor. I already know there's no possession of weapons as well, but I want you to understand me clearly. That's why I'm saying no possession of body armor, no possession of weapons. Do you understand?
Yes, Your Honor.
150 hours community service restitution. I'll order the stress education course. Once he's completed that, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Y'all do a referral to Veterans Treatment Court. There should be no contact with HEB. You're gonna have to go somewhere else other than an HEB.
And he's been going somewhere else. I think HEB doesn't want him there either, so.
And there's to be no contact with the following persons: Seferino, Lopez, Diane Lucera, and there's to be a mental health evaluation and a TAP evaluation. Out of custody, follow all recommendations. Regular reporting by Zoom or in person, regular random UAs. Probation, is there anything else? Yes, or with minors.
Yep.
And there's to be proof of employment within 45 days.
And Judge, he does work, kind of does freelance work, and he's been doing that consistently. The court adjusted his probation, his bond conditions to allow him to do that.
Yes.
You know, he's been complying with the court's orders and that. So we'd ask that if the court's going to keep on GPS and be in keeping with what the adjustments were made on the bond conditions.
Oh, yes, he's allowed to work.
Yeah.